of the court, or they leave. Two options.
Good morning. This is a matter of the state of New Hampshire. Excuse me, versus Megan Stewart. Before the jury comes up, I just wanted to talk to counsel and Stewart to make sure that there are no questions and you understand the proceedings. Ms. Stewart, is that correct? Any questions?
Well, I had one question. The disorderly conduct charge, what exact RSA I'm being charged with? Because it says 2C on the complaint, and the motion to amend has the first section of that.
Well, you could have looked it up.
I tried to look it up a few times. I just wasn't quite sure if it was going to.
If I may, Your Honor, the complaint need only have the general statute, which is 6.42, and that's what's on the complaint. That's all that needs to be on the complaint.
Would you like a copy, or would you like to look at it?
No. I wrote it down.
I'm happy to show you the statute if you'd like to see it. Specifically, Mr. Wood, the statute reads as follows. The person is guilty of disorderly conduct if she knowingly obstructs vehicular traffic on a public street and knowingly refuses to comply with the lawful order of a police officer to move. Lawful order means a command issued to any person to stop her from continuing to engage in disorderly conduct by obstructing vehicular traffic when the officer has reasonable grounds to believe that said person is presently engaged in conduct which constitutes said offense. And then there's a knowing definition. I allowed the state to amend the complaint to add the mental state, which had been inadvertently omitted on the basis that the state could have re-indicted you on the matter, and it just seemed like a simple way to proceed. The jury is about to come in, as you probably appreciate. The state, as well as yourself, are entitled to make an opening statement to the jury as well as a closing statement. The state will proceed with presenting its case, following which you may present your case. And obviously the jury will make a determination as to guilt or innocence. Do you have any questions about the procedure or what to expect? State have anything further?
I would only ask whether that word has actually been put on the complaint knowingly, or do I need to add that before it's read to the jury?
It's been added. And it's been added in the fashion that...
Want to see it, John?
Man.
I should show it to Ms. Stewart as well. And I'm assuming that Attorney Webb, that it's the state's position that Ms. Stewart had to act knowingly, not only with respect to obstructing vehicular traffic, but in refusing to move.
Yes, with respect to the disorderly complaint. The knowing element applies to both actions.
And I'm assuming that if the jury does not find that Ms. Stewart engaged in disorderly conduct, obstructing government administration is gone.
If they don't find that she engaged in unlawful conduct, specifically disorderly conduct, in order with a purpose to interfere, then yes, the disorderly conduct, the obstruction would be done. Yes, to answer your question,
Well,
be short, one word.
It doesn't have to be with purpose to interfere. If they conclude that she's not guilty of disorderly conduct, as will have been defined to her, and as I just read to Ms. Stewart, then, as a matter of law, the obstructing government administration disappears.
They should find that they're not going to do that as well. Yes. I have proposed jury instructions, but it sounds like you've already got them worked out. It's only, there's nothing special in there, just the statutes.
We'll take a recess after the evidence is concluded, and the court will discuss with Ms. Stewart and yourself proposed jury instructions.
Thank you.
I just have one question. The motion I received for amend, to add her manually, it was to the disorderly charge, and this is added to the obstruction charge. Oh.
Yeah.
I also wanted to bring to your attention, Ms. Stewart, that one of the jurors who we chose on Monday, I guess it was June number 12, who was pregnant, has difficulties, and she is unable to make it today. So the alternate has been, we have lost our alternate, but we still have 12 jurors. Anything further to come before the court on this?
No, not from the state, Your Honor, thank you.
Understood. Is jury ready?
Oh, should be like this, right? Well, it just looks like that. Thank you very much.
Jury, Your Honor. Thank you. Good morning, ladies and gentlemen. Please remain standing. Ms. Stewart, please remain standing. The rest of you may be seated.
You can see it now.
Ladies and gentlemen of the jury, will you raise your right hand and keep them raised during the oath? And at its conclusion, you will each say, "I will." Do you solemnly swear or affirm that you will carefully consider the evidence and the law presented to you in this case, and that you will deliver a fair and true verdict as to the charge or charges against the defendant, so help you?
I will.
Members of the jury, you may be seated. Ms. Stewart, please remain standing while the complaint is read to the jury. Ladies and gentlemen of the jury, will you please listen to complaint number 2011-S-14, charge number 367425C, charges that Megan Stewart at Central Square, Keene, on the 18th day of July, 2010, did commit the offense of disorderly conduct, contrary to RSA 644-2, in that the defendant did obstruct vehicular traffic on a public street, to wit, Central Square, by standing in front of a fully marked Keene police cruiser and refusing to move after being ordered to move, and that the defendant acted knowingly. Complaint 2011-S-14, charge number 387001C, charges that Megan Stewart at Central Square, Keene, on the 18th day of July 2010, did commit the offense of obstructing government administration contrary to RSA 642:1, in that the defendant did engage in unlawful conduct, to wit, disorderly conduct pursuant to RSA 644:2C, with the purpose to hinder or interfere with a public servant, to wit, Officer Colin Zaymore of the Keene Police Department, performing an official function, to wit, the defendant stood in front of Zaymore's fully marked police cruiser, blocking its path so that a prisoner located in said cruiser could not be transported to the police station. Ladies and gentlemen of the jury, the defendant, Megan Stewart, has been arraigned on the complaints and has pleaded not guilty, and of this, she places herself before the jury for trial. John Webb of the County Attorney's Office has joined the issue for the state, and you are to say by your verdict if the defendant, Megan Stewart, is guilty of the offenses whereof she stands charged, or not guilty. Listen carefully to the evidence. You may be seated.
Good morning again, ladies and gentlemen. As I advised you on Monday, this is anticipated to be a one-day case. I expect it to move quickly, and it will begin with opening statements by the state and the steward. As I indicated to you then, I believe if any of you have any problems or questions or difficulties during the course of your service, please bring it to my attention and to the bailiffs, and we will attempt to deal with it. We will do our best to keep this case moving quickly. Usually we experience delays despite our good intentions. Please bear with us. We will be working even if there is an unexpected delay. I think that's all I need to tell you. Stay ready to proceed with opening statements.
Yes, Your Honor. Thank you.
Good morning, ladies and gentlemen. You're here today serving on the jury in the case of the state versus Megan Stewart. As you've heard, that's docket number 11, CR 114. There are two charges under that docket number: disorderly conduct and obstructing government administration. You've already heard those complaints read to you, so you have an understanding of what the state is alleging. These charges arise from an incident which took place right here at Central Square in Keene, both in the circle where the little park is and on the street, the circle around that park. On July 18th, 2010, at about 6 p.m. or shortly after. And you're going to hear from three witnesses from the state, officers of the Keene Police Department. You're going to hear from Officer Colin Zaymore of the Keene Police Department. You're going to hear from William Sargent of the Keene Police Department. And you're going to hear from Officer Jason Thompson of the Keene Police Department. From these witnesses, you will learn the following facts. On that date, July 18, 2010, at about 6 p.m., Officers Thompson and Zaymore were dispatched to Central Square. There had been some complaints that had come in, and they were dispatched there. Now, you'll hear from Officer Thompson that he had already been there that day, not long prior to this. And when he was there was a gathering of people, and some of those people were drinking from open containers, in other words, drinking beer, okay, in the park. You'll learn that there's a city ordinance that prohibits that. He gave them at that time warnings, telling them this, you can't do that in the park, in a public place. Now, you know that there's nothing illegal about drinking beer if you're over 21 in your home or in a restaurant, but there's an ordinance that prohibits it in a public place like a park, like Central Square. Thompson had to leave. And then at 6 or so, 6 p.m., he gets called back along with Officer Zaymore, as I said. When they arrive, there is this gathering of people there. And some of those people are drinking alcohol, which, again, the city ordinance prohibits you from doing that. They gave out some hand summons, which means you can essentially get a ticket for minor offenses. Instead of getting taken into custody, arrested, and taken to the police department. You can just, if you're willing to cooperate with the process, you just get a hand summons. This is your ticket, and it will have all the information on it. You don't have to go to the police department. The officers had to deal with one woman, not the defendant, who was there in the park, and she was drinking from an open container of beer. She also happened to be getting her breast painted by someone. There's no specific ordinance against that, and so she was not taken into custody ultimately for that, but she was drinking from an open container. Now again, it wasn't that she was under 21, it's that you can't drink alcohol in parks, public places. They talked to her name was Heike Corser, for a long time, trying to persuade her that it would be much easier if she'd just take a hand summons for the open container, rather than get arrested and have to go all the way to the police department. She did not cooperate with that. She did not want to receive a hand summons. Ultimately, the two officers decided to place her under arrest because she would not cooperate with a hand summons. So they had to take her under arrest. They decided to take her under arrest and process her at the station for the violation. They take her into custody. They bring her to Colin Zaymore's cruiser, which is parked on the circle of Central Square, right over here. You know, the street, public street goes around the park, and he was parked right next to the park in the circle. They brought Heike to the circle. They put Heike in the cruiser. They were then going to take her to the Keene Police Department, which is, of course, down the street, not too far. However, they were unable to do so, you will hear, because a number of the people in the group decided to block the cruiser from leaving. So Zaymore is trying to leave, but he's got people now standing in front of his cruiser, and people then standing behind his cruiser. So he's hemmed in. He cannot move. Officer Thompson, who is outside the cruiser, is trying to persuade them, just get out of the way, move, you have to get out of the way, so he can leave. They decide they don't want to do that. So you're going to hear from the officers about that. The defendant, Megan Stewart, was one of those people who was blocking the cruiser and would not move so that Zaymore could leave. She was specifically told, she and the other fellow that was with her, they were standing at the front. This is a guy named Wesley Gilraith. He's standing in front of the cruiser. Megan is standing in front of the cruiser. Thompson goes right up to them, points, and says, you gotta get out of the way. Words to that effect. You'll hear from him, right? Get out of the way of the cruiser. She does not, neither does Wesley. So they're both placed under arrest for blocking the cruiser. All right, simple as that. There was another person who was standing in the back, and he was placed under arrest eventually, and another guy who wants to stand in front of the cruiser, he's placed under arrest. But today we're only here for Megan Stewart, who was standing in front of the cruiser and refused to get out of the way when she was told. Those are essentially the facts of the case. You know, there's a little bit more to it. You'll hear from the officers, but that's the case in a nutshell, factually. The law, you will receive instructions on the law from the judge, and his instructions control. Okay, so I'm going to summarize it briefly here, but he's the one you have to take the instructions from. If there's any contradiction in your mind between my summary and his instructions control. There are two charges: disorderly conduct. There are a number of different types of disorderly conduct. The one that's before you right now is when someone knowingly blocks vehicular traffic on a public street. There's others blocking traffic, vehicular or pedestrian traffic, for example, on a sidewalk in a public building. And there are other forms of disorderly conduct, but the one before you today is knowingly blocking vehicular traffic on a public street. And then continuing to do so when you're told to desist, when you're told to stop. All right, so that's disorderly. Now, obstructing government administration is essentially doing anything unlawful with a purpose to hinder or interfere with a public servant who's in the process of performing one of their functions. Okay? The public servant is performing his official function. A person purposely interferes with that function. That's obstructing government administration. So those are the charges. There's a lot of other law. I'm going to leave it to the judge to explain to you all the rest of the law, okay? And you need to pay attention to him when he does that. At the end of the trial, the state anticipates the evidence is going to show beyond a reasonable doubt that the defendant committed these crimes. These are not the crimes of the century. Obviously, they're misdemeanors. The person is entitled to a jury trial if they want one for misdemeanors, and so here we are. I ask you to consider all the evidence, listen carefully. I thank you very much for your patience, and soon we'll start with the witnesses after the defendant has a chance to do her oath. Thank you.
Let's go.
I'll make this quick because I don't plan to contest any of the facts in this case. But I did what I did because we're here today to hear about law. But when law is construed to no longer protect people, it actually has the opposite effect. And it makes victims out of people who have done nothing wrong. They haven't hurt anybody, they haven't damaged anything or caused loss or anything. So these people, these peaceful people, are aggressed against by the very people who are meant to protect them. And I was a witness to that on the day that we're discussing. And I just couldn't in good conscience allow somebody to be kidnapped the way that they were being taken away, because I care too much about people. And you as a jury, you have the right to do the same thing that I did that day and use your conscience. Despite what the law says, you can find me not guilty, simply because while the state can show every fact that I may have violated something, they cannot prove that I created a victim that day, because nobody was hurt by my actions. And I didn't cause damage or loss. All I did was try and protect somebody from harm that was being brought about by the state itself. And so I just ask that you listen to everything and decide for yourselves whether I'm actually a dangerous person or a person just looking out for the better good of everything.
Thank you, Your Honor. State calls Colin Zamor. Walk to the front, please, and remain standing. Officer Zamor, please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth under the penalties and pains of perjury?
I do.
Could you have a seat, please? And then state your full name and spell your last name for the record.
My name is Colin Zamor. Last name is spelled Z-A-M-O-R-E.
Officer Zamor, what is your current occupation?
I am currently employed as a full-time police officer for the city of Keene.
How long have you been with Keene?
Just over 3 years.
Have you worked any other law enforcement jobs?
Prior to that, I worked for the Chesterfield Police Department for 5 years.
Drawing your attention to July 18th, Sunday, 2010, around 6 p.m. Were you on duty for the City of Keene on that date?
Yes, I was.
And were you in full uniform at that time?
Yes.
And did you get a dispatch at around 6 p.m. to Central Square here in Keene on that date?
Yes.
How did you get there?
Originally dispatched myself and Officer Thompson to Central Square for a report of people consuming alcoholic beverages and taking their clothes off.
All right. Did you respond to Central Square?
I did.
What were you driving?
I was driving a low-profile Keene police cruiser, which the only difference between that and a fully marked cruiser is that I did not have a light bar on the top. I had low-profile lights.
Okay, but otherwise...
Otherwise, it's a fully marked on size
Police cruiser. Police cruiser.
Yes.
All right. I want you to, you got to the Central Square here and just describe for the jury where it was that you parked your cruiser on that day, July 18th.
When responding, myself and the other officer were traveling northbound on Main Street, so as we approached Central Square, the common and the gazebo area to our left, we pulled our cruisers up along the right side of the common and parked our cruisers there with our rear lights on.
Okay. Right in the circle, but up against the common?
Yes, on the roadway up against the common.
All right. Now that circle that goes around Central Square, which is right over here, that's a public street open to the public, right?
Correct.
I want you to explain to the jury, please, when you responded to the park itself, you know, inside the circle. Describe for them just the scene, who was there, not in terms of names, but just generally people and what was going on.
In the beginning, when I exited my cruiser, there were not a whole lot of people. I would say maybe 4, 5, 6. There was a female sitting on a park bench, kind of off near the water fountain area to the left. There was another subject on the opposite side of the water fountain sitting on a park bench. And the female that was to the left had her shirt off. She was having her breast painted. She was holding an alcoholic beverage in her hand along with the male who was on the other side. He was also holding a beverage as well. It was alcohol. Okay. This particular person that was holding, you said alcohol, what was it? What was it? Beer or something? Yeah, it was a Budweiser beer.
Okay. Open?
Yes.
This person, was this the hiker Corsa person?
The female, yes.
All right. There is a Keene City ordinance, is there not, that you can't drink alcohol in a public place like a park, is that right?
Correct.
Now, you had a interaction with this woman hiker Corsa that was holding the beer and getting her breast painted, is that right?
Yes.
I want you to explain to the jury that interaction.
Okay. After approaching her, again, she had the beer can in her hand. She took a couple quick chugs of it and then was willing to hand it to me. And in speaking to her about what was going on, I would say just off in the beginning, probably out of nowhere, 15, 20 more people all of a sudden arrived within Central Square. It was, when speaking with Heike, she was told that, you know, it was a city ordinance and it was against the law to be consuming alcoholic beverage in a public place such as Central Square. She refused to identify herself except for her first name. It was explained to her that the options at that point were going to be that she could be issued a summons for the open container, or she was physically going to be arrested. And I just want to make note that in speaking with Officer Thompson, when we backtrack a little bit, when we've been responding to the city, and he advised me that he had actually been in Central Square, I think 20 minutes, 30 minutes prior to the call that we were now dealing with. and he had actually given warnings to people for possessing and drinking open containers of alcohol. So at this point, the choices given to her were either the summons or she would be physically arrested and brought to the station, and then she would be processed and given a summons at that point.
All right, let me just interrupt you for a moment. She actually acknowledged to you, did she not, that she heard Officer Thompson give that warning previously, right?
I don't recall if she did or not.
Okay. Explain a summons, what a summons is, just briefly, as opposed to an arrest. What's a summons?
Basically, a summons would be in lieu of an arrest. It would be documentation, a piece of paper with a subject's information on it, stating date, time, who they are, and the offense would be listed as well. In this case, it would be open container. It would probably contain a court date, or it would contain a date to which they must answer to the complaint within.
All right. So with a summons, a person just gets that piece of paper provided they cooperate and they don't actually get taken to the police department.
Correct.
All right. You tried to persuade Heike to accept the summons versus getting arrested, didn't you?
For probably, I'd say, a good 10 minutes at least. It was not my intent or interest really to take her into custody, but I tried to let her know that basically the same action as being arrested and finally being released would be the ultimate. The end would be the same as if she took the summons right then and there. I thought it would be better for her to do it because she could continue being in Central Square and join the day.
Okay. While you were doing this, however long it took, 10 minutes, whatever it took, trying to persuade her to just accept the summons. What were these 15, 20 people, however many, what were they doing?
A lot of screaming, a lot of yelling. They did not want the police there. They were very vocal, telling us to leave, and saying that there was no victim in this matter. They didn't want us there. They pay our salaries. Don't we have things better to do? It was so much talk. Everybody was talking over each other, and it got to the point where I couldn't even hear. If I was talking to Heike, I couldn't hear what she was saying. I'm sure she probably couldn't hear what I was saying, and having a normal conversation was impossible.
Okay. But ultimately, you let her know that she was going to be arrested if she didn't accept the summons, right?
Yes.
All right. And she heard that?
Yes.
As far as you could tell?
Yes.
All right. She was seated during this conversation where? Where was she seated?
On a park bench.
All right, and where were you?
I was about 2 to 3 feet in front of her, and it was clear in my mind that she knew that she was going to be arrested because at one point she had the painting stop and she actually put her shirt on in preparation for being arrested.
All right. Officer Thompson then steps in, and what does he tell Heike?
I don't know if he gave her one more chance. I think he did to take the summons, or she would be arrested. She was, when informed that she was being placed under arrest, she was told that if she didn't stand up, that she was going to be charged with resisting arrest as well.
All right. What happened next?
Officer Thompson and I, she wasn't going to stand on her own, so we each took just a hold of each arm, and as we did so, kind of helped her to her feet, but she more or less assisted us, but wasn't going to do it unless we were right there.
All right. And then you had to walk her from that park bench in the middle of Central Square in Little Park over to your cruiser in the circle. Just briefly describe how that go.
In the beginning, Heike was able, it seemed like she was cooperating, walking with us. About halfway there, she began to struggle and try to break free from our grip. The crowd continued to kind of swarm around the sides, didn't really go into the front of us at that point, but certainly stayed with us as a group, and the yelling and the screaming and all that continued.
Okay. Eventually, you put Heike into handcuffs, is that right?
Yes.
And then placed her where?
She was put in the back of my police car.
In your police cruiser that you came in that you described?
Yes.
Okay. So she's in the back now, handcuffed, Heike that is. And explain what happens next.
At that point, I get into my cruiser, and as I'm trying to leave, there are now people standing in front of my car, and in back of my car, preventing it from going forward or backwards.
All right, so you're getting ready to take hiking to the police station, right?
Yes.
Okay. People in front of you, people behind you, blocking you. Were these people in front of you, were they standing right in front of your cruiser?
Directly in front of my cruiser
And facing your cruiser.
me.
All right.
Facing my car.
Anybody in the courtroom today that you see that was in fact one of those people that was standing directly in front of your cruiser facing the cruiser?
Yes.
Could you point him or her out for the jury and also the judge?
The female sitting at the defendant's table with the glasses.
And the record reflect the witness identify the defendant, Meg Stewart.
Director LaRusso.
So, Megan, the defendant, standing in front of the cruiser, someone else standing in front of the cruiser. There was a guy in front of the cruiser, Wesley Gilray, is that right?
Yes.
All right. And they're standing next to each other right in front of the cruiser, and somebody's behind you, so you can't go anywhere.
Correct.
All right. Describe for the jury, please, what did Officer Thompson do to try to assist you so that you could leave in your cruiser?
I believe he tried to speak with the people in back of me briefly. Obviously, it's easier to try to pull forward than it is backwards, so I think I had to speak with them. He then came to the front of my car. He came up along the right side, and although I could not hear what he was saying, it was clear that he was having a direct conversation with the two people in front of my car. At one point, I saw him point over towards Central Square, and it was clear he was telling them to move.
Okay. And so when he's doing this, you say you saw him pointing as if telling them to get out of the way.
Yes.
You saw him talking to them.
Yes.
And you said the defendant was one of them.
Yes.
How close roughly was Officer Thompson to the defendant when he's giving these instructions?
I'd say no more than a foot and a half.
In other words, he was right there.
He was right directly next to me.
They did not move, I take it. All right, so they didn't budge. Nobody's budging. She stood her ground, even after being told to leave. Get out of the way now.
Correct.
Okay. So then what happened?
At that point, I could see that Officer Thompson was placing handcuffs onto Megan, so that's when I began to exit my cruiser, and hopefully both the two subjects were arrested. Officer Thompson requested that I secure Megan in the rear of my cruiser and bring her to the station.
Okay, so Megan is placed in handcuffs and placed in a cruiser and ultimately ends up at the police station.
Yes.
All right. Other people had to be arrested because they wouldn't move either.
Correct. I think at least another two were arrested as well.
Okay.
Objection? I don't see the relevance to that.
Overruled.
You have described the crowd circling, yelling, so forth. What else, if anything, were they doing?
There were multiple people, as I said, either some kind of recording devices, whether they were cell phones or video cameras or things of that nature.
So it appeared at least that they were taking pictures, taking video, things like that?
Yeah, something along those lines.
All right. Have you had an opportunity to view video of this incident, which was taken off the internet?
Yes, I have.
All right. And the video that you have viewed, while not a complete videotape of the entire incident, the video that there is it fair and accurate in terms of what it depicts that happened that day?
Yes.
All right, so both the video and the audio, to the extent of what they capture, is accurate, right?
Yes.
Did you bring with you a copy of that video today?
I did.
You have it with you right now?
I do.
Now approach the witness.
May.
May the record reflect you're handing me a disc. This is the copy of the video that you have viewed that captures some of the events of that day, is that right?
That's correct.
This is the one that you said was accurate with respect at least to what it captures.
Yes.
I'd like to have this marked as a full exhibit. This may take me a moment, Your Honor. I didn't want the noise of the projector to be interfering with people's ability to listen.
Stuart, you're free to move if you want to take a different seat so you can observe the view.
This is marked as a full exhibit. I request permission to show it to the jury.
Proceed.
Now, on this disc that you have handed me, which is now State's Exhibit 1, full exhibit, it actually contains a video which is clips of the entire incident all put together. Is that right?
One of the videos, yes.
Okay. To be clear, this video was not taken by members of the police department, and the voices heard in it are not police officers, right?
The people yelling?
Yeah.
Yeah, those are not police officers.
All right. Until I get all set up here. See if I can melt that lens down. There is, in this video, there is writing actually imposed on the screen. The police department did not put that writing. That was part of the original video, right? Right. All right. Let's see. Now this first image is actually, that was Thompson pouring out alcohol, right?
Hey, you're using, you gotta watch how the government treats people. And the police that you paid for.
Let me just... All right, I'm gonna pause it for a moment. That is you with the sunglasses, correct?
Correct.
And the folks that are screaming, those are the folks you were talking about yelling?
Yes.
This is after you had the long conversation with Heike in the park, right?
Yes.
You've now placed her under arrest, and you're putting her in the cruiser, which is on Central Square, is that right?
That's correct.
A little fuzzy, sorry about that, folks. And there is, in the back, for example, a picture of a person taking a picture, like you were talking about. A lot of people taking videos and pictures.
Jobs. What the fuck is the matter with you? How can you do violence against a peaceful fucking person? How can you do that?
And this is trying to support order?
About to back over somebody. Hey, you're using force again. Then you're hurting your belly. What force are you using to initiate that? Violence is wrong. I don't need to hurt you. Put your hands up.
Now, you had testified earlier that Wesley Gilraith and Megan Stewart were standing, that is the defendant, was standing in front of your cruiser so you couldn't leave. That right there is Wesley Gilraith and the defendant, Megan Stewart. Is that right?
That's right.
Come on!
And we just saw an officer pointing his arm and speaking to them, and then it fades out and jumps ahead to when he's handcuffing. That's Officer Thompson, is that right?
That's correct.
And that was what you were testifying about when he pointed to the square and spoke to them?
Yes.
All right.
If you all come out what the fuck is the matter? That's all you're doing. Why are you doing oh, no victim, no crime! No victim, no crime! You guys are the aggressive violence against this man. Is this why you swore duty to protect? Why did you chain him? Why? We want to know.
Now another officer.
Can you stand up before we have to stand you up?
That's William Sargent, right? Officer Sargent? Yes. Assisting Officer Thompson?
Contractor. Watch your head. Nothing but mercenaries. You get paid to enforce the contract. You guys have created a disturbance here today.
That's not a police officer talking,
We were
right?
having a peaceful time in the park until you guys showed up. How many more? How many more in case your accuser? No victim, no crime. No victim, no victim, no crime. No victim, no crime. No victim, no crime. No victim.
All right. That pretty much captures the part about people blocking the cruises, right?
Yes.
And again, you had a long conversation with Heike, trying to persuade her just to take a summons in the park prior to this.
Yes.
Lens cap's smarter than I am. There we go. All right, thank you. I have nothing further. You may inquire now.
What's the purpose of your job?
The purpose of my job? I guess it's to, you want to use the old cliche, protect and serve. It's to, I guess, be there to help the people in need. They call the police department, and we don't have one specific area that we deal with. We deal with every single complaint that will come in.
And when you arrested Heike, who were you protecting?
Who was I protecting? I guess, in a sense, I was the only thing I can answer that is I'm, upholding the laws of the city.
But you can't name a person that she was being violent or aggressive towards?
She was not being violent or aggressive towards anyone when I arrived.
Was she at any point violent?
Not necessarily violent. I mean, when we were walking her to the cruiser and she was trying to struggle to pull away, I mean, I guess that would be the only thing you consider.
But
kind
she
of
didn't
but
hurt anybody or threaten anybody?
not that I'm aware of.
Did you at any point see me yelling?
If you did, I didn't see it.
Was I argumentative or combative with you at any point? Was I posing a threat to anybody?
I would say maybe standing in front of a police cruiser, standing in the middle of Central Square could maybe pose a threat to motorists in short fashion, but
you can't name a person that I threatened.
I don't have any reason to believe you threatened it.
And I didn't act violent at any point.
Not that I'm aware of.
And can you provide any proof that I worked in association with anybody who was there that day?
In what sense?
Did you see me conferring with people to do the things that I was doing?
No,
Did anybody ask me to do what I did?
I'm not aware of that.
So, for all you know, I acted completely on my own volition.
It's very possible.
Can you provide any proof that I even knew the people there that day?
No.
So, she wasn't violent, you didn't see her hit anybody or threaten anybody, but she did not do what she was told when she was told to get out of front, right? Okay, thank you. Looking further.
Almost done now.
State calls, just go. All right. William Sargent. Just walk up to the witness stand, please, and remain standing. All right, if you would raise your right hand, do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, under the penalties and pains of perjury?
I do.
You can have a seat, please. And Officer Sargent, we'll just be very brief on this. You were a Keene police officer on July 18, 2010 in Keene about 6 p.m.
I was.
And you were on duty on that date, and you got called to assist other officers at the Central Square. Is that correct?
That's correct.
All right, you showed up at Central Square, which is the circle around the little park over here, and very briefly describe the scene as you pulled up.
As I pulled up, I noted there were 2 Keene police units already off. The cruisers were on the east side of the square itself. Officer Zamor and Officer Thompson were engaged with a number of civilians, somewhere between 12 and 20.
All right, and what were those civilians doing?
Being very raucous, they were yelling, "Let him go," verbally debating some sort of an issue with the officers. I noted that there was a subject under arrest seated on the ground.
Okay. Now, by the time you got there, the subject on the ground, that was this guy, Wesley Gilreath, is that right?
Correct.
All right, so by this point, they've got Wesley handcuffed, but he doesn't want to walk, so he's sitting, or apparently, in any event, he's sitting on the ground. So the defendant, Megan Stewart, she's already been taken into custody.
I would believe so.
All right. So you just witnessed the scene with all the people being raucous, I think is what you said.
Correct.
And there were people still blocking the cruisers. You assisted the officer who had handcuffed Gilraith, getting Gilraith to a cruiser, is that right?
Correct. That was Officer Zamor. We lifted him to his feet, placed him inside my unit.
All right. And then you tried to leave and someone blocked you, is that right?
That's correct.
All right. So you took, what did you do?
Exited my cruiser, placed the subject under arrest, escorted him back to my cruiser, put him inside.
And that was pretty much your role, is that right?
Yeah, third individual sat on the bumper of my cruiser. He was removed as I backed away, and I left the scene.
Yeah, that was the guy without the shirt, the Richard Paul guy?
Correct.
All right. All right, thank you.
You arrived after I was put in the cruiser, correct?
Excuse me?
You arrived after I was put in the cruiser already, correct?
I really couldn't tell you when I got there. I dealt mostly with Mr. Gilraith.
Okay. Did you see me at any point?
I did not.
Okay, so your purpose here today is more to give testimony as to the events of other people?
I was subpoenaed here by the county attorney's office.
Nothing further. State calls Jason Thompson. No problem. It's gonna take a minute, Ron. All right, Officer Thompson, if you could remain standing and raise your right hand. Swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth under the penalties and pains of perjury.
I do.
You have a seat. State your full name, please.
Jason Thompson.
And what's your current occupation?
I'm a patrolman with the Keene Police Department.
How long have you worked for Keene?
I've been with Keene since January 2006.
All right. So, date July 18th, 2010, you were a Keene police officer?
Yes, sir.
All right. I want to draw your attention to that date, July 18, 2010, about 6 p.m. Were you on duty for Keene PD?
Yes, I was.
Were you in full uniform?
Yes, I was.
All right. Did you get a dispatch to Central Square around 6 p.m.?
Yes, I did.
All right. On that same day, just prior, had you already been to Central Square?
Yes, I had.
And just briefly, what did you do there the first time you were there, prior to the 6 p.m. call?
The first time I was dispatched to Central Square for a concern of a male subject drinking out of the fountain there. When I went there and spoke to that subject, I observed 2 females consuming alcohol in Central Square. I know those 2 females to be associated with Free Keene and typically know that in dealing with...
That just constitutes prejudice.
There's nothing prejudicial about his knowledge, or...
I'll overrule the objection.
All right. So let's just jump ahead. You issued a warning to the folks that were there about open container, right?
Yes, I did.
Just the nature of that warning was what? I mean, what did you say to them?
I explained that they can't be having or consuming open alcohol containers while in public, which included Central Square.
All right. You left?
I did.
Gave them a warning, you left, and then you get this call back around 6 p.m. You and Officer Zamor actually got dispatched to the square again, right?
Yes, sir.
All right. When you got there, you found some folks drinking beer, is that right?
I observed a male that had a beer can in his hand, and he set it down, and I went and approached him.
All right. Let's just summarize, you ended up giving him a summons, did you, for open container?
Yes, sir, he's very cooperative, and I issued him a summons at my police cruiser and kicked him loose, yes.
All right, so he wasn't taken into custody, you just did the ticket or whatever you call it?
Yes, sir.
All right. Now, Officer Zamor, the jury's already heard testimony, was dealing with this person, Heike Corser, who was sitting on a park bench. After you were done with your individual, you came over and observed that, is that right?
Yes, sir.
All right. Just briefly, could you explain to the jury what took place during that interaction?
Yes, sir. Basically, after I cleared with this subject, I could see several people that had surrounded Officer Zamor. Officer Zamor was trying to talk to Heike Corser. Meanwhile, these people around him were just badgering him with comments and trying to interfere verbally with what he was doing. So I went over to see if I could assist. I stood there for a while, and then I tried to interact with these people to kind of help Officer Zamor. Officer Zamor was explaining to Heike that he only wished to issue her summons. He did not want to place her into custody, but needed her cooperation to do so. I would say that Officer Zamor went on for at least 5 minutes, I would say 10 minutes, but basically pleading with her to cooperate, so we did not have to take her into custody. She decided not to cooperate whatsoever. It was decided that she was going to be placed into custody, which meant bringing her to the cruiser, handcuffing her, and transporting her to the Key Police Station.
All right. And you actually did that. You had to sort of assist her to her feet because she wouldn't get up, is that right?
Correct.
And you took her over to the cruiser, during which walk she became a little bit cooperative.
Yes, resistive. Yes.
But you eventually got her to the cruiser.
Yes, sir.
She was placed in handcuffs and placed in the cruiser. Is that
Yes,
right?
sir.
All right. So Heike's in the cruiser, and that was Zamor's cruiser, right?
Yes, sir.
All right. Explain what happened next. You got Officer Zamor's got Heike in his cruiser. He's getting ready to go to the police station. What happens next?
Okay, when we approached the scene, I had positioned myself right next to Central Square. It's still being a lane of traffic, but we were parked there with Officer Zamor in front. So when he was securing her into the back, I went around to the passenger side of his vehicle. So when he was ready to exit, I could temporarily stop traffic so he could leave. However, members of Free Keene were yelling for people to get into the roadway and block our cruisers in. There was probably 4 or 5 people at this time that were in front of Officer Zamor's cruiser. So I kind of just motioned to him backwards. Whether or not he saw me, I have no idea. However, Officer Zamor started to put it in reverse so he could back and go around these people that were blocking him in. At that point, members started jumping in behind the vehicle. At that time, I tried getting those people out of the road. They were resistive. So I went up to the front of the cruiser where a female and a male were standing right in front of Officer Zamor's cruiser with their arms crossed. At that time, I instructed them that they were to get out of the road or they would be placed under arrest.
All right, and you were standing how close to these 2 people, when this male and this female, when you talked to them?
A few feet.
All right. And is one of these people in the courtroom today?
Yes.
Can you point him or her out for the jury and the judge?
The female sitting at the bench.
All right, so she's the female standing in front of Zamor's cruiser?
Yes.
All right. Now, they've already seen a video, and it shows an officer standing next to the defendant and this guy, Whisper Gilray, pointing to the square. Is that you?
Yes, sir.
All right, so you were pointing and telling them that they had to get out of the way. Is that right?
Yes, sir.
All right, and did they?
No.
All right. So they refused to get out of the way. They're standing with their hands crossed, you said, and so what do you do?
They didn't move. They'd be placed under arrest. They did not move. So I placed the female under arrest.
All right. Now from there, the defendant gets placed under arrest. She doesn't wrestle or anything, right?
She's extremely cooperative.
All right. But she did refuse to move.
Yes, sir.
All right. You had to move a bunch of other people also who popped up and got in front of the cruiser.
Yes, Wesley, at this time, it was clear that we were going to need a lot more help. Officer Zamor got on the radio, requested more units. I was placing Wesley, the other male, under arrest. He dropped to his knees. So I asked Officer Zamor to secure the female, who I later identified as Meg Stewart, to secure her in the back of his cruiser, which he did. When Officer Bill Sargent arrived, he assisted me with carrying the other male subject to my cruiser where he was secured in the back.
Now, you also have seen videos that were taken off the internet capturing the events.
Yes, sir.
There's a few of those videos that are.
Yes.
And you've seen those different videos?
Yes, sir.
And to the extent that they depict the events of that day, you know, so the quality is not always that good, but to the extent they capture the events of that day, they're accurate in terms of the audio and the video.
Yes, sir.
In the video. Permission to show states 1 to the witness, Your Honor, and I would note that this is the second video on states 1. Now this is a poor quality video.
Hi, we are broadcasting live from Free Keene.
Now this person talking, this is not a police officer, right?
Johnny Ray is being given a ticket. We've had 2 police show up to attack the peaceful people here.
This is actually
all over their legitimacy.
This is you giving out.
I just can't stand it when
Yes, sir,
somebody
that was the
challenges
first
their
mail that I
legitimacy.
encountered when I went there.
So they've got to come in and show that we're in charge, we're the gang here, we've got the guns, you'll do as we say, such it.
Now, there's no connection that you know of necessarily between this guy talking and the defendant, to be fair, right?
No.
Yeah. All right. Now, what are they looking at now?
Now they're looking at Officer Zamor's interaction.
You have a beer in your hand. Take a picture of this officer with his beer in his hand.
This is Zamor talking to Heike with a crowd around him?
Cops are here engaging activists, folks.
Doesn't matter.
You don't have to identify yourself, Frank.
Do I not have to? There we go. As you say, I think.
I know, I just... Sure, can't you use discretion? No one's being harmed, there's no victim.
Were you here earlier when that officer came over?
I was.
Warned you guys?
She just said she was
To
there.
get rid of my beer, I took it down, he got
You can use it again,
So, Heike was there, actually, when you went the first time, is that right?
Yes.
And she got the warning, no open
Yes.
container. All right.
Why did you guys in the back of use of discretion? Who's being harmed here? Did you find some victim the first time you guys came out, or is it just that your authority was challenged? Okay. I mean, it seems like you guys are coming out here because your legitimacy is being challenged openly here in the public, so you guys want to come out and show that you're in charge and that you're the violent gang that runs shit
I'm
here.
drinking a beer, but I'm not harming anyone. I'm sitting here calmly.
Okay. No, guys, people complained about someone getting water out of the water fountain. And then you guys came over here and started trouble.
That's why you're here.
We did.
Who was it, this guy? What was wrong with filling up water out of the water fountain?
I don't even know how to complain.
Well, that's how you guys came about.
Complaining isn't just...
Are you arresting me? Are you arresting me?
If you don't want to summons, then yes.
I do not want a summons, but I also don't want to be arrested.
Looks like they're trying to arrest Micah.
You would like to go on your merry way. I, again, wholeheartedly say, please be safe and protect and serve as your job states.
If you don't want to summons, you got it.
I'm not having a summons. Why?
What happened with Chastity?
What is my charge? What? Open container.
So here you are about to initiate force on a group of peaceful people to uphold your own legitimacy. You should really be ashamed. Why would you waste anybody's time?
Wow, look at who. Why?
She's in the middle of something.
There's a female in the back with a camera. On the right. That's the defendant, right? In the back there?
I can't see.
Okay. Let's watch.
Come back later. She doesn't want your services right now. I didn't create it here. This is First Amendment protected.
Thank you.
Like it's going to be arrested because she's failing to...
Yes.
Defendant holding a camera?
Yes.
With the group?
Yes.
All right.
Again, I need to be at work at 5:30 a.m. so get my ass out by then.
And we have, if you have grievance, there's no way for you to Why would that? No, we don't have to go to the station. You can turn around and walk away.
I'm also supposed to have a summon. My option is a summon for being arrested. I don't need
you can just walk away.
Mr. Public Servant, I pay your salary. I'd like you to go away now.
Yes. Me too. Let's vote. Let's vote. Who wants the police to leave? They're outnumbered. We're going to go away. I'm sorry. I would like to go home.
We actually see the defendant on the lower left there voting for you all to go away. Is that right?
Yes.
Yeah.
You haven't survived. Take a look around you. It's not good. Does any of this register that nobody here wants you to do what you're doing? Why don't you just go away and leave people alone?
What are you doing holding that car? You need to write yourself a ticket. Oh.
It's wonderful thing, but there's no need to There's no reason. Somebody else's property. You're going to pack it.
Why would you take away paint from an innocent painter? You just
First Amendment privileges on a lovely pair of fools.
That's you right there in the back, right?
Yes, sir.
Okay.
They're lovely. Aren't those beautiful fools?
No, you know what? I'm not showing any indecent exposure.
Why don't you guys just go away and find a real crime?
No indecent exposure. Breasts are not genitals. They arrested Cassidy and they've arrested her falsely because they goddamn knew she hadn't committed any crime. Just like they arrested me falsely in the fucking county jail and they to get her out of the way. That's the protection. You're not following your own laws in your interaction with us. I don't even care what the Bible wants. Falsely arrested at the county jail.
You only do with this mess.
Why do you arrest what they do? They're not here to serve anybody.
Tell someone.
In order to get around the Fourth Amendment, that's not cool. It's not cool. What happens if Micah doesn't go?
I'm taking her to a game.
What happens if Micah doesn't go?
What if I don't go?
Well, no, you don't have to go.
It's violent.
Why don't you just admit the violence?
I'd rather you just walk.
You'd rather not be violent with people, but you're perfectly willing, aren't you?
You know what? I am not doing anything wrong by sitting here on this bench. I'm being very peaceful. I'm not.
You realize that all they want you. Nobody even wants you guys here. What are you doing?
And go away.
Dead until dead.
No, use your discretion, gentlemen.
Do violence against human beings. It's not enough reason.
And how do I know what you're doing? Can I see your
You're just stand here and let the that would be good. I think you should go in with your That's like being told at a one-night stand that I'll call you. Don't worry. Why are you touching her? Why don't you guys go somewhere where you want it?
Go away.
Nobody asked you. Nobody asked you here.
Well, you heard dispatch. Go ahead and check. Call here.
What for? Maintenance. There's a problem. And who's being harmed? Why is one person more valuable than 30 Your topic is disorderly, because this was orderly. Yeah, it was until you guys showed up and caused the problem. Well, you don't have to involve us. Is that right? We're having a good time, and you're hard. Some people are terrorists will in. No, you're the president. Oh, I trust you. Oh, yeah. And you're not
I completely agree. These cops should not be out here. They completely
watch your services. This is your last chance to watch this. You don't want charge. This is your last chance. No one wants charge. You're addressing additional.
That was you saying this is your last chance?
Yes, sir.
All right.
Man, you're hurting people.
Interestingly, is the defendant. Is that right?
Yes, sir.
Now, at this point, she's on a bicycle, right?
Yes, sir.
Okay.
Peaceful people, hey, what's up? Protecting and serving, nothing to see here, folks. Nothing to see here. Nothing to see here, folks. Just police breaking up a peaceful park gathering. You have the right to peaceably assemble unless they say so. Just the police trying to trouble our people gathering. With the rock somebody. Stop your car. Protest. There's no reason for this arrest. There is no reason for this arrest. Stop your car. Protest. Get the bike.
Now, Kenny or some name, will you get my bike? That was actually the defendant, right?
Yes.
All right. So the defendant's called to somebody, get my bike. She gives the bike to somebody. The guy that's screaming is the bald guy with the beard and the no shirt, right?
Yeah, that's Richard Paul.
Richard Paul.
They're protecting and bringing their job.
There's been no harm here.
There's been no crime. They did it.
There's been no crime. Who are you protecting?
The only harm here is the harm that you guys are creating.
You can
still create it, okay, no. What the fuck is the matter with you? How can you do violence against the people? Calm down, man. How can you do this?
At this point, we've got the defendant with the pigtails and the white shirt standing next to another individual in front of Zane, right?
Yes.
How do you support order? How do you prevent chaos?
Ian is running around to the back of the police car.
Now that was you just saying you guys got to get out of the way, right?
Yes, sir.
All right.
Hey, you're using force again, man. You're how much force are you guys willing to initiate today, huh? Violence is wrong. Why can't you just leave peaceful people alone? Come on, get the SWAT team out here. Maybe an assault rifle would fix this situation. Come on.
All right.
Maybe an assault.
So that was the point where you just told them you got to get out of the way or you're going to be placed under arrest?
Yes, sir.
All right. They did not move?
Yes.
You're arrested?
Yes.
All right.
Rifle would fix this situation, huh? Clearly, we don't have enough violence. This This was a peaceful situation until you guys showed up. Thank you very much for creating this disturbance, for harassing peaceful people. You should be so proud.
That person talking is the guy with the camera, right?
Yes, sir.
Sort of in your face?
Yes, Sam Dawson.
How many people do you guys have to arrest in order to keep up your own legitimacy? Because that's all you're doing here.
At this
Your
point,
legitimacy was challenged, and now you guys got to show the lies. It's
we don't need to watch the rest of it. They saw it in the other video. Megan's already in custody. But that captures what was happening that day.
Yes, sir.
And the hiker was given every opportunity to take a summons, but she did not cooperate.
Yes, sir.
All right. You guys didn't want to take anybody into custody that day. All right. Megan stood in front of the cruiser. You went right up to her and Wesley and told them, you've got to get out of the way.
Yes, sir.
And you pointed to the park when you did so.
Yes, sir.
They did not budge.
No, sir.
All right. Thank you. You may inquire.
First, I'd like to bring something to their attention that was on the video somewhere. Okay, around the 4-minute, 40-second mark, show that.
Get there.
Play from here.
I'm so fearful.
No, you know what? I'm still not showing any indecent exposure.
Why don't you guys just go away and find a real crime?
No indecent exposure. Breasts are not genitals. They arrested Cassidy and they arrested her falsely because a goddamn goon she hasn't committed any crime.
You can actually
Just like
see
me.
that at that point I had left. I had walked my bike out of the scene, and I was no longer within, as they call it, the group. And every angle that shows this interaction from then on, I am not within that at all. So I just wanted to bring that to people's attention in this video. Okay. Now for you, when you first visited the park during the first call, did you see me there?
No, I did not.
And when you came out the second time, did you see me drinking?
No, I did not.
Did you hear me say anything?
No, I did not.
Did I yell anything?
No, you did not.
When Hiker was arrested, at one point, did she scream out in pain?
Yes.
Okay. And did she claim that you were one of the people who caused that?
Yes.
And when you came up to me, was I threatening anybody at that
No.
point? Was I violent or dangerous?
No.
Okay. And after you put handcuffs on me and went after Wes, you just left me standing there in handcuffs alone, right?
Yes.
Okay. And if I had run at that point, I would have been chased after. Right?
Yes.
Okay. So I was just standing there and you were struggling with Wes, right?
I wouldn't say struggling, but yes, he was resistive.
Okay. So it's easy to say that I was just standing in the street in handcuffs, unable to leave without being chased. So I was potentially in danger had somebody bumped into me during that altercation.
I would say that you were right in front of the cruiser and I was right next to you.
But I could have easily been bumped into traffic.
Yes, that's why I wanted you to go to Central Square.
Okay, but after you put the handcuffs on me, had I moved, I would have been chased after and probably given some sort of resistance.
Yes.
So you actually put me in a more dangerous position at that point.
I don't view it as that way.
Mr. Will you approach King Webb? gentlemen, I just want to instruct you that whether Ms. Stewart is supportive or a member of Free Keene or not is absolutely irrelevant to purposes of your deciding this case.
Thank you, Your Honor. Just a couple more questions to you, Officer Thompson. You were asked on cross whether at one point during her arrest, Heike screamed out in pain, and you replied in the affirmative. She clearly screamed out. Whether she was in pain or not is not something that you could know, right?
Absolutely.
All right. And did you guys use a reasonable amount of force to get her to the cruiser?
Yes.
Did you use any excessive force?
No, sir.
All right. All right, nothing further. Thank you very much.
Thank you. Ms. Littell.
Rest, Your Honor.
You can approach Mr. Wood. Thank you. Ladies and gentlemen, take a brief recess and stretch your legs, discuss the evidence among yourselves at this point. When you come back, we'll have closing arguments, and I will instruct you as to the law that applies in this case. Thank you.
Prize for the jury.
Jury, Your Honor. Thank you. Please be seated. Ms. Stewart, make a closing statement.
Do I move there?
Wherever you come from.
So today you saw the prosecution primarily focus on what everybody else is doing, because there was actually very little that I did that day. I was quiet and calm, as they all stated, and nobody out of that group that they were talking about created a victim. Nobody caused harm, damage, or even threatened anybody there. And as a jury, you have the power to look at that and say, you know, use your conscience and find me not guilty simply because I didn't do anything wrong. I didn't create a victim. I didn't harm anybody. And maybe the law has been skewed. Maybe the law created a victim that day. I know I personally saw somebody get hurt by somebody who was said to protect people. And that frightened me, because I don't know how far that's going to go in the future. How far these laws are going to be taken to the point that they can hurt people like that for doing nothing. For a girl who was simply enjoying a drink on a bench. She was hurt, she was kidnapped, she was taken away from us. And I had to do something. I'm a person of compassion. And I hope that you all are too, because I'm not a criminal. And I just hope they can find me not guilty, because you have the power to do that. And unlike me, there's no consequence for you if you do that. You can follow your conscience, no matter what the law says. You have the ability to say not guilty simply because I am not a violent person. I'm not afraid. So I ask that you find me not guilty.
Thank you, Your Honor. Well, thank you very much for your patience in this case. The defendant's absolutely right. You have the power to find her not guilty. The state would argue that the evidence in this case shows that she is guilty. She obstructed vehicular traffic in a public street. She did so knowingly. She acted with a purpose to hinder Officer Zaymore as he was trying to carry out his function as a public servant, get his arrestee to the police department. So clearly the evidence shows that she's guilty of the 2 crimes charged. Now, I don't think you can see it, but I can see the flag over there. And it reminds me that yes, in our society there is a place for certain things. Peaceful protest, and that's when a group of people who disagree with something that's happening in their society will gather, perhaps with signs, and take a stand for something. Sure, our society has that long history, and we should respect it. Our society even has a history that is one step past peaceful protest, and that is civil disobedience. Now, opinions will differ as to where civil disobedience should be employed. And you search your own souls as far as that goes. Civil disobedience is usually reserved for laws which are intrinsically immoral and single out a particular group, or for example a race or gender or a religion. When laws get to that level where certain groups of people are singled out, civil disobedience is sometimes required and, you may say, should be respected. But this is not that case, okay? Open container ordinance. Why do we have ordinances like this? We want our kids to be able to play in the parks without worrying about what nonsense is going to be going on in the park. Simple as that. So we vote for, we put these ordinances in place. There's a process for that, and that's why we have them, especially public places where we want to take our kids without worrying about what we're going to see or hear. All right? So there's a place for peaceful protest and civil disobedience. This is not the place, but you decide. The evidence shows she's guilty. I want to say I commend her. She is to be commended and respected for the fact that she was not screaming like a lunatic. Yes. That's commendable. She wasn't being obnoxious like some of the others. That is commendable. Being obnoxious is not an element of these crimes. Okay? She did obstruct traffic. She obstructed the cruiser from being able to leave. She was told to stop. She did not. She had a purpose to hinder a servant, Officer Zaymore, trying to get his arrestee to the police department. So the evidence clearly shows she's guilty. Again, to the extent she was not obnoxious that day, of course she's to be commended. So the evidence shows she's guilty. The state asked you to find her guilty. Again, the defendant's right, of course. You can vote. You have the power to decide whether she's guilty or not. Thank you very much for your patience.
Before I instruct you on the law that applies in this case, ladies and gentlemen, during the recess, there was some concern apparently expressed by some of you, all of you, as to whether you were being videoed during the course of this trial. The answer to that is no. The camera is not trained on you whether you're coming in or leaving or doing this process. The rest of us are being videoed apparently, but you are excluded from that and should be. So I hope that puts any concerns or fears to rest that any of you may have. As you know, the evidence and the arguments in this case have been completed, and I will now instruct you on the law that applies in this case. You will then retire to decide a verdict. In order to reach a fair and just verdict, you must understand and follow the law as I explained it to you. For example, you have to understand the definition of the crimes with which the defendant is charged. You have to understand how convinced one way or the other you should be before you reach a verdict. You have to understand what to consider in deciding whether to believe a particular witness. These instructions will explain the law as to these and other matters so that you can reach a fair and just verdict. It is your duty as jurors to follow all of the instructions I'm about to give you. Regardless of any opinion you may have as to what the law ought to be, the law as I explain it to you is the law you must follow in reaching your verdict. If any of you intend to leave, please leave now. I think it's disruptive to keep getting up during the course of these instructions. So if you're staying now, the door is going to be locked and you're not going to be allowed to leave. If any of you want to leave, you're free to do so, but please do so now. As I indicated, it is your duties as jurors to follow all of the instructions I'm about to give you. Regardless of any opinion you may have as to what the law ought to be, the law as I explain it to you is the law you must follow in reaching your verdict. It is up to you to decide the facts in this case. You must decide the facts solely from the evidence in this trial. You must apply the law given to you in these instructions to the facts, and in this way reach a fair and just verdict. You should decide the facts in this case without prejudice, without fear, and without sympathy. You should decide this case based solely on the evidence presented and the law as I explain it to you. The fact that the defendant, Megan Stewart, has been charged or accused and brought to stand trial is not evidence of guilt. The complaint is simply a way of giving a defendant notice of the charge against her. The complaint is a formal way of accusing the defendant of the crime charged in order to bring it to trial. In your deliberations, you must not consider the fact of the defendant's complaint or the defendant being brought to stand trial as evidence of guilt of the defendant. The possible punishment of the defendant if you return a guilty verdict should not influence your decision. The duty of imposing sentence is for the judge. You should consider the evidence presented and base your verdict only on the evidence without considering the punishment. You have heard the state and Ms. Stewart discuss the facts and the law and their arguments to you. These arguments are not evidence. Their purpose is to help you understand the evidence and the law. If the parties have stated the law differently from the law as I explain it to you in these instructions, then you must follow these instructions and ignore the statements of the parties. If the parties have stated the evidence differently from how you recall it, then you should follow your own memory of what the evidence is. During the trial, Ms. Stewart made objections. Parties are supposed to object when they believe that certain evidence is not admissible. That's their job. They're not trying to hide anything from you. If I sustained an objection or excluded any evidence, you must not guess as to what the answer or evidence would have been. If I did allow some information to be entered as evidence after, hearing objections of one of the parties, you are not to give any such evidence any special importance as a result of my ruling. It is not my duty, and I certainly did not try to determine whether evidence was important when I made my ruling. During your deliberations, you should consider only the evidence in this case. The evidence from which you are to decide what the facts are in this case consists of the testimony under oath of the witnesses, both on direct and cross-examination, regardless of who called the witness, and exhibits which have been admitted into evidence. If you believe that I have expressed or suggested an opinion as to the facts in this case, you should ignore such an opinion. The court in this case, as in all cases, is completely neutral and impartial. It is up to you alone to decide the facts in this case. In short, you should consider only the legally admissible evidence in deciding this case, that is, the testimony of the witnesses and the exhibits. Under our constitutions, all defendants in criminal cases are presumed to be innocent until proven guilty beyond a reasonable doubt. The burden of proving guilt is entirely on the state. The defendant, Megan Stewart, does not have to prove her innocence. The defendant enters this courtroom as an innocent person, and you must consider her to be an innocent person until the state convinces you beyond a reasonable doubt that she is guilty of every element of the alleged offense. A person accused of an offense has an absolute right not to take the witness stand to testify. The fact that the defendant did not testify must not be considered by you in any way in deciding this case. The burden is on the state to prove the defendant guilty beyond a reasonable doubt. If after all the evidence and arguments you have a reasonable doubt as to the defendant having committed any one or more of the elements of the offense, then you must find her not guilty. A reasonable doubt is just what the words would ordinarily imply. The use of the word reasonable means simply that the doubt must be reasonable rather than unreasonable. It must be a doubt based on reason. It is not a frivolous or fanciful doubt, nor is it one that can easily be explained away. Rather, it is such a doubt based upon reason as remains after consideration of all of the evidence that the state has offered against it. The test you must use is this. If you have a reasonable doubt as to whether the state has proved any one or more of the elements of the crime charged, you must find the defendant not guilty. However, if you find the state has proved all of the elements of the offense charged beyond a reasonable doubt, you should find the defendant guilty. In reviewing the evidence, you should consider the quality of the evidence and not the quantity. It is not the number of witnesses or quantity of the evidence that is important, but the quality of the evidence that is important. In deciding whether the state has proved the charges against the defendant beyond a reasonable doubt, you must decide the credibility of witnesses. That is, it is up to you to decide who to believe. If there is any conflict between the witnesses, then you must resolve the conflict and decide what the truth is. Simply because a witness has taken an oath to tell the truth does not mean you have to accept the testimony as true. You are the sole and exclusive judges of the facts, of the credibility of all the witnesses who have testified in the trial of this case, and of the weight to be given to the testimony of each witness. In deciding which witnesses to believe, you should use your common sense and judgment. I suggest that you consider a number of factors. The witness's appearance, attitude, and behavior on the stand and the way the witness testified, the witness's age, intelligence, and experience, the witness's opportunity and ability to see or hear the things about which he or she testified, the accuracy of the witness's memory, any motive of the witness not to tell the truth, any interest that a witness had in the outcome of the case, any bias of the witness or friendship or animosity the witness may have for or against any of the parties of the case, consistency or inconsistency of the witness, whether or not what the witness has said appears reasonable or unreasonable, and whether what the witness said is consistent or inconsistent with the testimony of the other witnesses. In deciding which witnesses to believe and how much of their testimony to believe, you should consider both the direct and cross-examination of the witness. You should consider these factors in deciding the credibility of all of the witnesses. In short, you should consider the testimony of each witness and give it the weight you think it deserves. You can accept all of what a witness has said, you can reject all of what a witness has said, or you can accept some of it and reject some. I will now instruct you as to the substantive law that applies in this case. The laws in New Hampshire set forth certain crimes. If it is not defined in the criminal code, it is not a crime. Each crime has a precise definition. The definition of each crime requires that the state prove both that a defendant committed certain acts and that the defendant acted with a criminal intent. So all crimes have at least two parts, an action and an intention. In deciding whether a person is guilty of a crime, it is necessary for you to know both what a person's actions were and what the intentions were when the act was committed. The word intent, of course, refers to what a person mentally believes their physical acts will accomplish. The word act refers to a physical deed or action. For a person to be guilty of a crime, they must do both things. In other words, the defendant must have mentally intended to do something that is criminal. She must physically act to do something that is criminal. Unless a defendant both intended and acted to do something that is defined as criminal, that person has not committed a crime. The matter of intention of the defendant's mental state is something that you will have to decide. Each of the complaints against the defendant constitutes a separate offense. You must consider each complaint separately and determine whether the state has proven the defendant's guilt beyond a reasonable doubt. You should consider the complaint charging the defendant with disorderly conduct first. If you find the defendant not guilty of this charge, then you must find the defendant not guilty of the charge of obstructing government administration. If you find the defendant guilty of disorderly conduct, you must then consider the defendant's guilt or innocence of the charge of obstructing government administration. The defendant is charged with disorderly conduct. A person is guilty of disorderly conduct if she knowingly obstructs vehicular traffic on any public street and knowingly refuses to comply with a lawful order of a peace officer to move. Lawful order means a command issued by any person to stop her from continuing to engage in disorderly conduct by obstructing vehicular traffic when the officer has reasonable grounds to believe that said person is presently engaged in conduct that constitutes said offense. Part of the definition of the crime of disorderly conduct is that the defendant acted knowingly. A person acts knowingly with respect to conduct or to a circumstance that is a material element of an offense when she is aware that her conduct is of such nature or that such circumstances exist. Specifically, the state must prove that the defendant knowingly obstructed vehicular traffic on a public street, Central Square, by standing in front of a fully marked Keene police cruiser and knowingly refusing to move after being ordered to do so. The defendant is also charged with obstructing government administration. A person is guilty of obstructing government administration if that person engages in any unlawful conduct with a purpose to hinder or interfere with a public servant performing or purporting to perform an official function. Public servant means any officer or employee of the state or any political subdivision thereof. A person acts purposely with respect to a material element of an offense when her conscious object is to cause the result or engage in the conduct that comprises the element. Specifically, the state must prove that Ms. Stewart engaged in unlawful conduct, disorderly conduct, with a purpose to hinder or interfere with a public servant, Officer Colin Zamor, of the Keene Police Department, performing an official function, to wit, the defendant stood in front of Zamor's fully marked Keene Police Cruiser, blocking its path so that a prisoner located in said cruiser could not be transported to the police station. This case is important to both of the parties, ladies and gentlemen, of the state and the defendant. In your deliberations, you should follow these instructions which I have given to you. You should not decide this case out of bias or sympathy, but with honesty and with understanding. You should make a conscientious effort to determine what a fair and just verdict is in this case, because that's your highest duty as officers of this court. Remember that the verdict must be unanimous, that is, that all 12 of you must agree on the result with respect to each charge. Juror number 1, Mr. Callahan, would you be willing to serve as the foreperson for this jury? Yes. As foreperson, it's your job to oversee deliberations, making sure that everybody participates. If at any point a recess or break needs to be called, you should call it. Deliberation should cease unless all of you are deliberating as a group. I will give you copies of my instructions, which hopefully will assist you if you have any questions as to the law that applies in this case. If they don't, and you have a question as to the law that applies, you should write it down, sign it, date it. There will be a bailiff outside of the jury deliberation room. Indicate to the bailiff you have a question. I will review it with Ms. Stewart and Attorney Webb, and we will get you back an answer as quickly as we can. If you have questions as to the facts that apply in this case, you're going to have to use your collective recollection. The parties in the court cannot assist you in that. When you reach verdicts on these charges, don't write it down. Indicate to the bailiff you've reached a verdict. You will come back in the courtroom, and the clerk will inquire whether you reached verdicts, and if so, what those verdicts are. As I indicated, the verdicts must be unanimous, which means all 12 of you must agree on them. I think that concludes the comments I need to make to you, and I will excuse you to begin your deliberations. Thank you for your attention.
All rise, please.
Please rise and face the jury. Mr. Foreman, has the jury reached a unanimous verdict?
Yes.
How say you, Mr. Foreman, is the defendant, Megan Stewart, guilty or not guilty of the crime of disorderly conduct?
Guilty.
Guilty, you say?
Guilty.
So say you all?
Yes.
Yes.
How say you, Mr. Foreman, is the defendant, Megan Stewart, guilty or not guilty of the crime of obstructing government administration and disorderly conduct?
Guilty.
Guilty, you say?
Guilty.
So say you all. Thank you.
Thank you, ladies and
Proceed,
gentlemen.
Mr. Foreman.
I will excuse you and be done talking to you shortly. You're all set. Thank you.
All rise for the jury. What is your respect? That's all it is.
State wish to be heard in sentencing today, or do we want to schedule that at a later date?
We can schedule it at a later date if it pleases the court. Or we can do it today.
Thanks for the court. Ms. Stewart, do you have a preference?
Gotta get it over and done with.
Okay, go ahead.
Thank you, Your Honor.
You can receipt, Mr. Stewart.
Your Honor, for the court's information, the sentencing district court, it appears to be 90 days. House of Corrections, all suspended 2 years on condition of good behavior. There's no annotation as to how the two sentences interact, so I assume the presumption would be concurrent. You've now seen the video. The state would normally argue that anyone who engages in this kind of conduct, obstructing an officer's cruiser while he's trying to do his duty, should be incarcerated for some period of time, actual sanctioned time. At the very least, a fine should be imposed for that kind of conduct. So the state feels that all suspended time is inappropriate. That said, I think clearly of those who were arrested that day, the defendant is the least culpable. She, as you saw in the video, was not screaming, not obnoxious in that sense, nor did she physically resist in terms of dropping to the ground or anything of that nature. And so the state recognizes that she is less culpable than those others who were being more obnoxious. The state would certainly accept whatever sentence the court deems appropriate in this case, but again, it seems to the state that some amount of either a fine or sanctioned time would be appropriate for this kind of conduct. And even though she was not, it was not relevant to the conviction that she was shown to be directly associated with this group for sentencing purposes, the court can consider that she clearly was engaged with this group in this group activity and bears some kind of group responsibility. But again, the state will accept whether the court deems appropriate.
Good.
I have a question with group responsibilities.
If you want to be heard on sentencing, you can address me on sentencing. I think the state wants to answer that at a later time. You're welcome to do so.
Well, I think it's pretty clear that I'm not a threat to anybody and I'm not dangerous. Like, even the state pretended. So I don't think I should be locked in a cage or put away from society because I pose no threat to society. So I really just feel that I should not get any sort of sentencing, but I won't be paying fines. So if those are imposed, I'd have to take the jail time instead of the fine. But I certainly don't think I deserve anything. And I don't set any threat, so I don't think any jail time should be imposed.
The court is going to impose the sentence that was imposed by the district court. With respect to both charges, they are concurrent with one another, and as I understand it, Mr. Stewart, he was sentenced to a 90-day House of Corrections sentence, suspended for 2 years based on good behavior. Those are the sentences which the court is imposing today. I would respectfully suggest to you all, not that you probably care about my comments, that it would be probably more productive to try to change the laws that you find objectionable rather than thinking that the police and the court and the state is your enemy. There are certainly mechanisms in a democracy to change the ordinances or laws that you like. I'm sure you're all intelligent enough to realize that. I know you're all very pleased with your conduct, and that's up to you, but to the extent you want to accomplish something productively, there probably would be other ways to do it that would further your cause, whether somebody believes in it or not. So, I'm sure I will see you all again.
Your Honor, can I just, one last thing, I just want to make sure the defendant understands that the sentence is effective today, not when it was originally, she was sentenced to district court, so the 2-year period of good behavior begins today.
Any questions, Mr. Stewart? Thank you. Thank you.
Is liberty dying where you live? Escape to Keene at freekeene.com.
We'd like to invite you to visit freekeene.com. Freekeene.com features audio, video, and blogs chronicling the transition to a voluntary society. Freekeene.com also has comments and discussion forums so you can be heard. Freekeene.com.
I should be in Keene, New Hampshire with the Free Staters.